Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. It finally happened. It took about 5 years to get Julia Way in the studio. Real estate attorney Julia Way, welcome.
Thank you, Pat.
Now, the name of your firm is?
I'm an attorney with the law offices of Peter and Brewer.
Beautiful. And of course, you've been a guest speaker with us a couple of times at De Anza College.
Yes, I've had that pleasure.
Okay, and the topic was comparing a traditional sale with short sales, REOs, bank-owned properties.
And foreclosures.
And foreclosures. So let's just generally speak about that real quick. You hear that term all the time, short sales, and I get this question all the time from members of the public. What is a short sale?
Well, the simplest way to describe a short sale is simply that there aren't enough proceeds after the sale to pay off the mortgage.
Okay. Now, there could be a family in there with 2 BMWs, they're both making a lot of money, and just the value of the home went past the loan.
As there's been a lot of attention in the media about this, but many of those loans adjusted after the initial 2 or 3 year terms, and so the rates got so high that borrowers couldn't afford their loans after the first 3 years.
Sure. And then we have the traditional people who did put money down, but values went so far down in their neighborhood, now they're underwater.
That's correct. California was very hard hit.
Okay. Now, in terms of, I've also heard the term, we hear it often, is pre-foreclosure. So perhaps those people that are in the home and it's underwater or upside down, the value of the loan is way past the value of the house. Some families are making their mortgage payments and some are not.
Well, pre-foreclosure is about the timing in California before a foreclosure sale actually occurs.
Okay.
Traditionally, it took about a minimum of 4 months for a sale, a trustee's sale, to actually be conducted. So a pre-foreclosure was to describe that period of time before the trustee sale had happened, but after the bank had already declared a default on the mortgage.
So that was if they stop making payments, because the family with the BMWs, good incomes, they're going to continue to make their payments.
Well, the lender has a huge portfolio, so they're not really going to pay attention until you stop making payments.
Right, yeah.
So at that point, whatever the bank's policy is, whether it's 2 defaults or 3 defaults before they actually record a notice of default, it's the recording of the notice of default of the public records that actually triggers the foreclosure process in California.
Okay, and that's, we hear that term NOD, notice of default.
That's correct.
Okay, so once the home is repossessed by the bank, it goes back on the market, and we hear this other term, REO, real estate owned, bank owned.
Yes.
And you have mentioned in the past, that's very similar to a traditional sale, because you have a seller, and there's no one in the property. We're not going to be tied down with a short sale and dealing with all these lenders.
Well, an REO is a situation where the foreclosure has already occurred, so now the property is likely vacant. It's probably not occupied anymore, and the lender is trying to turn over the inventory and liquidate the asset. So in that circumstance, it is a traditional sale. The buyer can still finance the transaction. It's very different than a foreclosure sale where the buyer would be a bidder that has to pay all cash on the day of the sale.
And I know you see this more in terms of, you deal with a lot of people that buy foreclosures.
Yes, I represent a number of private investors, and so they will be more I think they're more of a risk taker, so they're willing to go to the foreclosure sales, and they do a lot of the research and due diligence before going to the sale, and they assume a lot of risk.
Yeah. And that's, you've mentioned in your outlines and whatnot, that those investors, they cannot inspect that property before they buy it.
That's right. I mean, in a traditional sale, you might have home inspections and a roof inspection and a termite inspection, but the foreclosure investor has, you know, the eyes in their head, the public record, and then basically whatever they can see from the sidewalk.
Over the years, regardless of the economy, people say, hey, I'd like to buy a foreclosure. How do you buy a foreclosure? Now, you're mentioning those clients that you have, they go to a foreclosure sale. That's actually on the courthouse steps.
In Santa Clara County, they take place right at the courthouse here at 191 First Street. So you can see them as you walk by. They happen almost every morning, and there is a crier there, and there's a crowd of people. They all have to be pre-qualified to bid at the sale. So they show up with a stack of cashier's checks like it's Monopoly money, and they fan it out, and they have to make change with the cashier's checks when they buy.
Wow. Now, we have spoken in the past, of course, before the show, you mentioned about the new laws coming out in January.
So in July of 2012, the governor signed into effect the Homeowners Bill of Rights, which had been spearheaded by Kamala Harris, the Attorney General. The Homeowners Bill of Rights will go into effect January 1st of 2013, and it's intended to reduce the foreclosure inventory in California. So it is to keep people in homes and make more availability of loan modifications and principal reductions to Californians.
Okay. Now that slowdown too, I think that would be helpful in terms of allowing that family to sell their house in a short sale if they want.
Yes. So as part of the federal national mortgage settlement, a number of lenders were supposed to allocate funds for things like refinances at more affordable rates, as well as principal write-down. And so where you see a principal write-down is in the approval of a short sale.
Okay. Now, I've had a lot of members of the public, by now they say, you know, I'd like to buy a house, but I really don't want to buy a short sale. I hear that takes forever. Why does that take so long, Julia?
You know, this is a mystery on the part of the banks and the asset managers, but there's an approval process, and that's what's happening on the bank's end. But on the part of the borrower, you know, in a traditional sale, the borrower is motivated to work with their professional, with the listing agent, and get the transaction going and fill out all the transfer disclosure statements and move the transaction along. In a short sale situation, it's possibly a borrower who hasn't been working, who may be very depressed, who hasn't been paying their mortgage.
Exactly.
And so their level of enthusiasm for the transaction is dramatically different from a traditional sale.
Right. Now, sometimes there's two banks involved, right? There's a first and second?
Often. In California, given our high purchase prices here, you'll often see either a first and a piggyback second, or else a home equity line of credit where someone had taken out money to remodel or maybe do some landscaping for their home. So
then the family that has a short sale, they put a sign on the lawn, they have all these open houses, they get an offer, 2 or 3, and they begin the process. The short sale does take longer than a regular transaction because at that stage, the lender hasn't said yes to the transaction. The lender is essentially agreeing to take a short payoff, a discounted payoff. So instead of receiving $500,000 on their loan, there may only be enough money to pay them, $350,000 on their loan. Therefore, the lender is going to have exercise some discretion at that point. And also behind the scenes, the first lender and the second lender might be arguing because I don't know how much communication takes place, but definitely they are trying to restrict the amount of proceeds that are allowed, right? I mean, typically the junior lender, which is the second or third position lender, there won't be any money left for them often. Right. But in order to make the short sale possible, in order to allow it to close escrow, oftentimes a senior lender will allocate a modest amount, maybe $5,000 or $10,000 to be paid to the junior lender. It could be 20 cents on a dollar or something. Or far less, even. Or far less. Now, in terms of making the offer, how does one make an offer on a short sale in terms of the timelines? Well, how does that work? A number of the publishers have a short sale addendum, and the addendum is helpful because it explains how to protect the buyer's deposit, and those timelines are not triggered until after the lender's approval. So the rest of the contract, they leave it alone, and so the 5 days, 10 days, 17 days for all of the inspections and contingencies, those only start after the lender approval if you use the appropriate short sale addendum. Okay, because I know when the recession started, people started buying homes and they didn't have the addendum, and we really didn't know it was a short sale yet, and all of a sudden you're in a short sale and the deposit's in, they spent $1,000 on inspections, and they're waiting to close, and uh-oh.
Well, and there's been case law in California about that. The listing agent, if they know, they are obligated to explain on the MLS that it is a short sale situation, because that's material to the buyer, because the buyer's ability to liquidate, to have enough money to close, their timing, all those factors are significant.
Okay, now you had mentioned in the past and at the class we had together that when a buyer's making an offer on a bank-owned property, they should put into the offer anything they'd like to see at that time.
Right. I mean, we've already talked about how long it can take to get the asset manager's attention. Well, you don't want to risk it twice.
Right.
So if you observe during your own inspection of the property that there are things that are going to need to be repaired, before you even wait for the counter offer process, you should put it in your offer the repairs that you anticipate or any repair credits that you want, such as Section 1 termite repairs, because the odds of trying to get it closer to the end of the transaction are going to be low.
Because what you're referencing is people at the beginning of the recession, let's say, would get into the sale, get the approval from the banks, and then start inspecting.
Yes.
And say, oh, time out, I didn't know about this. And now you have to go right back and start over.
Right, and with REOs, oftentimes those properties are not in very good condition compared to a traditional sale, because the homeowner has often deferred all the maintenance because they are already having trouble paying the mortgage.
Now, again, with the short sale, the family's still living in there. They're obviously not very happy. But we still have, they know about the property and they still have to fill out these seller questionnaires, right?
That's right. They're still mandated to complete the transfer disclosure statement, and if they have a good communication with their listing agent, they should also do the seller supplemental.
Okay. Now the seller supplemental, we spoke about that at our class. Can you touch on that? There's disclosures that a seller has to fill out in California.
That's
mandated.
right. The TDS, the transfer disclosure statement, is mandatory, and so those cover all the basic disclosures that the seller should mark as being a condition of the property. The supplemental is more of a, I mean, it's called a checklist, but it's also more to help jog the memory of the seller.
Yeah, there you go.
If you've owned a property for, a decade or 2 decades, there are probably a number of repairs and replacements you've done over the years, and they may not seem significant to you because as the owner you accept those idiosyncrasies of your house, but to a buyer, the property is totally mysterious to them, and so it's hard for you as a seller to know what's going to be important to the buyer. Therefore, we always advise people to disclose everything that they can recall having dealt with, and oftentimes I suggest attaching recent repair receipts. Let's say, for example, a window was leaking in January and you had someone out. If you sell the house in July, you don't really know if it's fixed or not, and you shouldn't assert that it's fixed. All you can say is that there's been a repair and here are the service people. It gives a buyer an opportunity to investigate, call, maybe get their own person in there to look and determine if they should seek a repair credit if it hasn't been totally repaired.
Okay. Now that's conversely, when it is bank-owned, does the bank have to fill out these forms?
No.
Okay, so that's a little risky right there. Right?
Yeah, the banks don't have, I mean, they're not living in the property, right? So they don't have any specialized knowledge of the property, and from the buyer's perspective, it's even worse than just not getting disclosures. I mean, the bank sometimes has their own form that they want to use that's unique to that lender.
Oh, that's true. Okay. Let's talk about that. We mentioned about the offer and, for instance, counter offers. When one is making an offer to a bank on a regular real estate form, typically they get a volume of paper back from the bank.
That's right. There's something else going on, which is the lender may be trying to get concessions out of the seller, which you wouldn't see on the buyer's end. But as a buyer, you will receive some boilerplate from the bank. But the drafter was likely not a Californian attorney or a California realtor, and so there'll be some unusual provisions in there, and they're all different. I mean, I've seen a variety of unusual provisions from the different lenders, and in some cases it makes people nervous to counter those things or strike them out because the buyer may not be comfortable signing it, but they don't want to jeopardize the transaction there.
Right.
Oftentimes I tell people, if this is a condition you cannot live with, you need to cross it out and counter and allow them to also initial anything you've stricken out of their boilerplate.
Okay, because the regular real estate forms are created by, as you mentioned, real estate brokers and real estate attorneys. I know I was on the local forum, and they brainstorm and change a paragraph depending on the market and the
That's
the laws.
right. The local forms committee, Peter was on the PRDS, and they worked very hard to scrutinize, the different provisions on the form and whether or not something should change based on business, custom, and practice or new law. Right. The same is true for the California Association of Realtors. They have talented realtors and attorneys who are devoted to managing these forms and seeing if they can improve the transaction.
Okay. Now, oftentimes those forms are written in layman's terms, right?
We hope.
We hope, especially the local form. Now, when the bank gives a counteroffer, which is 10 or 15 pages, and it comes from another state, that's a point where we have to stop and take it to a real estate attorney like you to say, what
That's often when we do get the call, because the reality is this is outside the scope of the buyer's experience and the realtor's experience.
Correct.
And sometimes those provisions may not even be valid in California, so it's hard to know how much risk to take. And so that's why I always say, when you're looking at a foreclosure, an REO, or a short sale, you're always assuming more risk than in a traditional transaction. Right.
And that's because the Silicon Valley people are coming and going. And I know on the East Coast, when they buy a home, they always have an attorney involved. But here we tend to only go to an attorney when we need help.
Well, the forms are intended to allow the principals to work with their realtors and complete the transaction without attorney involvement. I think where we see a lot of the need for attorney review is when the disclosures are huge, right? So if you're buying into a planned unit development or into an HOA, you're going to get disclosures that are, half a foot high.
Exactly. Now, in terms of the foreclosure process, people often ask me, how long does that take? Is that 6 months? Is it 4 months? Or, I'm buying this house, and they said the notice was just filed for notice of default, NOD, and I just bought it, and am I going to have time to close escrow?
Well, so the minimum amount of time in California would be from the time of recording the NOD, there's a 3-month reinstatement period before the notice is published. And with the publication has to take place over a few consecutive weekends. And so at a minimum, it takes 4 months from the recording of the NOD to the actual sale date.
Sure.
Now, the reality is when you look at services like Foreclosure Radar that track the amount of sales that are taking place in California, there are a number of postponements, so it's rare that the lender actually completes a foreclosure in that amount of time.
Okay. Now that ties in, do you think, well, the other topic is you mentioned Foreclosure Radar with the foreclosures going down 60%.
That's right. So in October, I think they released their recent report showing that just from September to October, there was a dramatic decrease in the amount of publications for sale. And also, if you look at a year comparison from this year to last year, it's been a 60% decrease. Wow. And so when we talk about available inventory, not only is there already a decline in what is going to foreclosure, but after the Homeowners Bill of Rights takes effect in January, it is intended to further reduce foreclosures in California. So there will be even fewer foreclosures next year, theoretically.
Okay. Now, oftentimes, by the way, you mentioned in some of your outlines, we talk about a loan modification. Can we just touch on that? What does that mean to the public?
So if the terms of your loan have now accelerated or adjusted, I should say, that's usually where the borrower is at risk, right? And so part of the national mortgage settlement was to, at least with those 5 lenders that had signed on to the settlement, was to give an opportunity to borrowers who were struggling, to give them an opportunity to try and refinance to more affordable terms.
Okay.
And a loan modification will actually change the terms of your original promissory note. So if you had agreed, I was going to make a payment of this amount for 30 years, at this interest rate, then the application for the loan modification is an attempt to change the terms of that loan, either extending the term from 30 years to 40 years, or tacking the arrearages, the missed payments to the end of the loan, or just bringing down the interest rate. That would be considered a modification.
Okay. Now, you mentioned earlier in the program about reducing the loan balance.
Those are principal write-downs, and they're fairly rare, but I understand anecdotally from clients that some lenders are offering it. I haven't seen a huge flood of those types of loan modifications. Instead, what we see is the principal reduction comes across in the short sale approval, because that is a principal reduction,
sure,
right? They're
exactly.
agreeing to take less than is owed.
Okay. Now, in terms of the notice, you mentioned if it's going to foreclosure, a notice has been filed, and they say, oh, why don't you try the loan modification? Is that new law going to?
So that's exactly the issue with the new law. So when the Homeowners Bill of Rights goes into effect in January, it's going to bar dual tracking, because what was confusing for borrowers before is that you had, on the one hand, you have this applicant who is submitting all their financials over and over every 6 months trying to get approved for a loan modification. But on the other end of the spectrum, with that same lender, they're giving instructions to the loan servicer to put that loan into foreclosure. So on the one hand, you have a borrower who thinks, oh, maybe I'm getting approved for a temporary loan modification and I'm making these probation payments, but after 3 months, maybe that changes and all of a sudden they're getting a notice of default, but they don't know that they're going through a foreclosure at that stage, because they think, I'm in communication with my lender, I'm going to get approved. So the purpose of this new law is that if you are in the application process, and there's a number of milestones in that process, the lender is under some very strict statutory prohibitions. They are not allowed to publish the notice of default or the notice of trustee sale if the application is getting approved or if it's pending and there hasn't been a response yet. So it's intended to remove the confusion that the borrower was previously experiencing if they were applying for a loan mod.
And having the rug pulled out from under
That's
them.
right.
Okay. Because I know we've interviewed the people from Project Sentinel many times, and they are a HUD counselor. And people come in with their paperwork and they don't realize they've been foreclosed.
That's unfortunately something we read about in the media a lot, because the actual foreclosure process can take so long with the lender postponing it that it's actually confusing to the borrower when the sale date even occurred. And so one of the changes to the law is that if the sale date is postponed, I think 10 days or more, they have to be personally served with the new date.
Nice. Another term that I hear about too is cash for keys. Since we're speaking about this topic, what is that cash for keys?
So for some of my clients who are investors, if they're purchasing distressed property, but the property is still occupied, cash for keys is a practical business method that investors use to work with the occupant about an orderly handover of the possession of the property. So in that circumstance, it's to avoid going through an eviction, essentially, and that's what the cash for keys has come to mean in this industry.
Now, would your people like your investors that you work with who buy on the courthouse steps, I would imagine they go to the home and there's still a family there?
It has happened. I mean, I think that's one of the primary factors they try to determine before they even bid on the property. Is the property occupied? Or in some cases, if the property is like a triplex or a duplex, or is some of it occupied?
I see. Now, what in terms of for buyers, we had a lot of buyers in the audience when we did the De Anza class. What is some advice you would have for them
Buyers on the foreclosure end?
On the foreclosure end.
I would say do your homework. I mean, we have seen on multiple occasions a novice bidder bid on what they believed was the first position loan, but actually they bought the second. So they ended up acquiring a property that's still subject to a first mortgage, and oftentimes that first mortgage is also in default. So not only have they now spent $200,000 or $300,000 or more of their life savings to buy this property at what they thought was a discount, only to learn that they now still have to spend another $50,000, $60,000 to cure the default on the first in order to salvage their investment.
Oh my gosh. What about in terms of a short sale, setting the expectations for a buyer, buying a short sale? What would you tell? It's a perfect home.
I think that short sale buyers often need a lot of flexibility because they need to be able to move their money and their possessions on a time frame that's subject to the lender's whim. Right.
Now, of course, for the sellers that are sitting in that home, they need to cooperate. What's some advice for them to help them get out of this?
Well, the interesting thing about the Homeowners Bill of Rights is it's intended to give new hope to troubled borrowers, and so for those who have been considering a short sale or think they're close to getting out of being underwater, it's intended to revive those opportunities if they were dispirited or discouraged about the process. Oftentimes, I think people get so frustrated dealing with the telephone menu when they call the lender.
Oh, the 800 number?
I've done it myself for clients before, and it is a test of your patience, really. So I would encourage those sellers to actually to take advantage of the new law that's in effect because it's intended to help them.
Beautiful. Julia Way, thanks for coming out today.
Thank you, Pat.
And the name of your law firm again?
The law offices of Peter N. Brewer.
Beautiful. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week. Thanks for watching.